All right, good afternoon, everyone. This is the Docketwise sponsored webinar on religious workers. I have with me Joel Pfeffer, an immigration attorney and longtime Docketwise user, who has as one of his niches religious workers. So Joel, welcome. Thanks so much for joining me as my guest for this webinar. Why don't we start off by just having you tell us about yourself and really how you came to concentrate on immigration law generally, and then specifically, how you got into the religious worker niche and how much of your practice is that these days?
Okay, James, thank you so much for having me. I got into the immigration field because our firm was in international work, and the partner who was doing it had a couple of cases, and he decided to give it to some young associate. And back then, the field of immigration law was basically in its infancy. And you could actually call the USCIS and ask them how to do a case. And eventually the field got much more sophisticated, and they screened the practitioners from the public, from the officers, and you have to learn how to do it yourself. And it's a word of mouth business. You get approved for one person, they tell the next person. And then you get move up the ladder to having corporate clients or religious orders or larger religious organizations, if that's your niche. And how did I get into religious work? I'm ordained clergy myself in the Orthodox Jewish denomination. And I knew some people, and I got a few cases and got them approved, and word of mouth spread, and people called me. Most of my work is concentrated in that denomination or in the Catholic Church. I do handle other denominations, but most of my work is either in the Catholic Church or in Jewish organizations.
And Joel, is it something that is, in other words, to get the big picture, why do denominations, why would they want to bring people in from other countries? Where does that need come about? When's it advantageous for them to do that? Are there denominations which are just, the Catholic Church, of course, is worldwide, and of course, Orthodox Judaism has adherents in many countries. But is it something that is a commonly encountered situation for religious denominations?
Well, let's take the Catholic Church, for example. There is a shortage of priests in the United States, and there are order priests abroad who are available to come. There are a shortage of nuns in the United States, and many of these orders have branches abroad, and they're seeking to bring sisters to the United States. And every religion has a need for to bring clergy, religious workers to the United States to perform these services. It's just like anything else, just like any other occupation. The only difference is that they're adjudicated differently.
Is it something that's been present in the immigration law for a long period of time, going back historically? Do you know? These religious worker categories certainly, they obviously weren't around in the 1800s or when the first immigration laws were passed in the early 1900s. Is it something which is of recent origin?
There are cases about clergy going back probably 100 years, but the idea of a non-minister goes to the Immigration Act of 1990, where the act introduced the idea of, as far as I know, it was introduced then, of non-minister cases, people who are engaged in religious vocation or occupation. That law established the R1 category for temporary religious workers and established the concept of permanent resident status for non-ministers, people engaged in religious vocations and occupations. And the regulations were promulgated, the current regulations were promulgated in 2008 after an investigation by the Department of Homeland Security in 2005 that led to the conclusion that there was a high level of fraud in these cases. I guess that's sort of ironic that and I find that to be the truth, that they perceive that every religious worker case is a fraud until you overcome that perception on their part. So you have to be heavy on the evidence, because they believe nobody in religious worker cases. They then promulgated these regulations in 2008 and introduced the concept of a site visit, which means that the USCIS typically comes to your petitioner's location and sees if it really exists, because they have a belief that many of these don't.
Okay, let me pause you right there, because we are going to get to the site visits. I definitely do. We are going to spend time on that, but I just let's sort of give an overview of some of the categories that we use in religious worker cases, and then when we go into the R1 and the I-360, we're definitely going to talk about the site visits. So there are a number of visa categories that can be used in religious worker cases. Now, everybody thinks of the R1, which is a non-immigrant visa specifically for religious workers. And then there's an R2, which is for the dependents of those religious workers. That has a counterpart. Those are non-immigrant visas. And Joel, if I remember correctly, my recollection is you can get it for 30 months at the first approval, and then another extension for another 30 months. Is that still the situation?
Yes, that's correct. It's a
Okay.
5-year limit, each one in 2.5 years. Now, sometimes you will have to go for a third extension, because you will not have used up your 5 years within those, all of the 5 years, because of the timing of the approvals. But yes, it's a 5-year limit, typically 2.5 years per application. But that's it. You cannot extend it. It's not like an H-1B where you have a permanent resident case pending and you can extend it beyond the statutory limitation. Here, you cannot do that. You can recapture time if the religious worker was out of the country, just like you can in an L or an H case.
Well, that's interesting. So if you're going to do a permanent residency process, you have to get that underway and be able to either adjust or otherwise apply for an immigrant visa by the end of those 5 years, because you're not getting any R1 extensions beyond the 5 years, is what you're saying. Can the R2 dependents, are they able to work in the United States?
No, they're not like an E or an L where they can work in the United States.
So that actually, I imagine, can pose issues for certain applicants, because then, if they're married, what do they do with their spouse, as far as the spouse's ability to earn a living in the United States? Do you have any insights on how people handle that?
Sometimes you get an R1 for the spouse for the same organization or a different organization. Typically these, I guess in the Catholic Church, they're not married, but in the other religions, you can get an R1 for the spouse and do it that way. Now, the concept of the 5 years means that you need to watch that clock. You cannot postpone the green card part of this side of the equation very long, because as everything else in the USCIS, the timing is unpredictable. And recently, I would say probably 6 months ago, it was taking a very long time to get either an R1 approval or an I-360 approval. And as a processing matter, you cannot file the adjustment of status I-485 together with the I-360. You have to wait until it's approved. So if you wait too long, you're sort of out of luck, because you file your 485 and you don't get your work authorization right away, because that's delayed too. That's unpredictable also. So that has put a lot of people off of payroll, out of work, and created a situation where you're considering whether or not the person is, let's say, a priest who's saying mass. I mean, is that permitted when they don't have employment authorization? So you've got a lot of questions that come up. The real question that comes up is, can you get them any other status? And the answer is maybe. You might be able to get them an H-1B if you can establish that the position is a professional one. Not all religious workers are professional. The positions don't all require degrees. The employees, the religious workers, don't all have degrees. And you have a quota problem. So you have to, if you don't want to go into the selection process, then you have to find an employer who's affiliated with the university or who is a university. So that's really not a practical solution. O1, yes, O1 is a possibility for an outstanding ability, extraordinary ability, priest, minister, religious worker. I just did one for someone who serves as a dean of a large school, elementary, high school. And reason I did it is because the processing delay on the R1 was so long last year that I said, this person will never get here for the start of the school year. You'll have to wait till next year. That was unacceptable to the client. So I said, okay, let's try O1. Frankly, it was a marginal O1 case. I was able to establish that the individual had played a significant role in a major religious seminary abroad. I was able to establish that the new employer was paying him significant money to come and take this position. But the problem was the person had not published and there was little written about him in the media. But I was able to secure the O1 nevertheless with the evidence that I had. When I tried to move that on to a permanent resident status, I was unsuccessful. But with a 3-year O1, I was able to file the 360 and get the 360 approved. So O1 is a possibility when you have somebody who can establish that they are risen to the very top of their field in religious work, either as a writer, as a teacher, as a minister, as a dean or principal of a school. These people, you can establish somehow or other that they have an international reputation. You can get an O1 for them, and then move on to the I-360 through religious work.
Got it. Let's that you've been talking about the O1 and how that could be used for a very high profile religious figure, but let's dig a little bit more into the R requirements first before we get onto these other categories. Let's just stick in there for a bit. So the R, you always need an I-129 to file for an R. There's no such thing as just showing up at the consulate or embassy with your packet and just doing a visa appointment without a petition first, right? You always need the petition.
There was a time when you could do that, but not since 2008. Not able to.
Do you know if you can get expedited processing on an I-129 for an R visa?
In theory, you can, but it's very difficult to get it. The expedite criteria provides that a nonprofit organization whose request is in the furtherance of the cultural or social interest of the United States can qualify for an expedite. But the example they give here is, let's see, where is that? A university professor needs to participate in an imminent cultural program.
Got it.
There's one here for clergy, but they're very narrow and very difficult to get.
You know, I said expedite, but what I really meant to say was premium processing.
Okay, okay. Premium processing, yes, is available in the R1, category if you've had a site visit. So if it's your first time, if your petitioner's first time, then you cannot get premium processing. It's a little tricky. Once the site visit occurs, you may file a 907, see if they take it. Sometimes they do and sometimes they don't. You cannot get premium processing for an I-360. It's not available.
Okay, so that's important. So it's not like where you're doing an H-1B transfer or something where you can just pay them $1,200 and get a decision in 15 days. This one, the R, you have to have a site visit, and that has to be finished and approved after the site visit before they'll even consider premium processing. Okay,
right,
so that's a limit.
The fee is $1,500.
$1,500 now.
For religious workers.
Got it. Okay, so with religious workers, we're talking about somebody who's either a minister or ordained clergy, or somebody who's in a religious vocation, which can be either a professional or non-professional capacity, or else in a religious occupation, either in a professional or non-professional capacity. Let's take this apart a little bit. What's the difference between a religious vocation and a religious occupation?
Okay, a religious vocation is available to men or women who have taken vows, lifetime vows, or investitures, or other formalities of the denomination that mean a lifetime commitment to the denomination. So for example, the Catholic Church That means a person has a nun, for example, has taken permanent vows. Temporary vows don't do it. You have to have taken permanent vows of I guess it's chastity, obedience, and to general lifetime commitment to the denomination. A religious occupation, on the other hand, is someone who is fulfilling a traditional religious function, a function that's related to the traditional a traditional occupation within the denomination, related to or involving teaching or instilling in others the religious creed and beliefs of the denomination. Now you have to prove all of that. They don't take your word for anything. But that's the difference. The difference is the vocation is someone who is made through a program in the denomination. This is normal in the denomination. And sometimes, even in the Catholic Church, you have to prove to the officer that there is such a thing as vows that are permanent and lifetime. Or else you have to show that the individual is fulfilling a traditional religious function.
Got it. And professional or non-professional capacity, that relates to the amount of education and training that's required to hold the job. Can we talk about that?
Well, professional and unprofessional is a word that is in the statute, but it doesn't have much meaning in this context. It doesn't matter whether you're professional or not. So you can be unprofessional or non-professional. You can be non-professional in a religious occupation. There's no need to show that a college degree is an entry-level requirement into this occupation. You can show it if you like, but it's not necessary.
Okay. All right, let's talk about what's required of the petitioner. So they either have to be a religious organization, meaning the denomination, or they have to be a bona fide organization that is affiliated with the religious denomination. So let's talk about those distinctions, especially what they mean by a bona fide organization affiliated with the religious denomination. Do they mean, let's say you're coming to work for, let's say, Catholic adoption services. You're not going to work for the church itself, but you're working for something affiliated. And I suppose that example is probably legit. Catholic adoption is probably a separately constituted organization run by the Catholic Church, but I think that's kind of what they're talking about. Do you want to elaborate on that, on what's the difference between the denomination and an organization affiliated with it?
Okay, that typically relates to something called the IRS determination letter. In order to get one of these cases started, the petitioning organization has to have a letter from the Internal Revenue Service that confirms that they are a charity, that their income will not be taxed. This is a bit of a complicated subject, but basically the first thing the practitioner has to know is do not get involved. First thing you ask your client, first thing you ask, do you have a tax-exempt determination letter from the IRS? If the answer is yes, can I see it? I can't, so many times I say yes, and they show me something that is not a determination letter from the IRS. It's a state tax thing or something else. And so you have to have a determination letter from the Internal Revenue Service. There is also such a thing as a group determination letter, which means that, for example, in the Catholic Church, every year the IRS writes a letter to the Conference of Catholic Bishops saying that everybody who is in your directory, the Kennedy directory or the Catholic directory, is tax exempt. So when you have such a case, you have your Catholic adoption agency. If they're in the Kennedy directory, then that proves that they're tax exempt. If they have their own tax exempt letter, then they stand on their own and they are tax exempt and they qualify as a petitioner. Now there's also a certification form on the 129 and on the 360 that requires somebody other than the petitioner to certify that this organization is part of a religious denomination. Now, for a while, for a number of years, there's been no attention paid to that certification, who is certifying and who's qualified to certify. Recently, I would say in the last 3 to 6 months, the USCIS has become quite fussy about who signs those certifications and what the tax exempt determination letter looks like. For example, the first thing the practitioner needs to understand is the Internal Revenue Service does not require a church, synagogue, or mosque to get this determination letter. So many such clients will not have them. Well, if they don't, then you cannot start your case, because the USCIS says, it's there in the introductory language to the regulations, that even though the IRS doesn't require it, we require it. So if your client does not have that, you're not going to be able to move forward with your case. You can't present it and wait for an RFE. It just doesn't work that way. So the first thing you need to know is your organization affiliated through this group exemption letter, or is it affiliated on its own? And if so, who signs that certification? So the first thing that the practitioner has to know is that your organization cannot sign it. It's got to be the basic rule is, if your organization is hierarchical, meaning there's a diocese and a bishop, somebody from the organizational level, for example, the Catholic Church, somebody from the diocese should sign that. If your organization is not, I'm not saying they have to, it could be another Catholic organization could sign it too. But if your organization is not hierarchical, in other words, there is no hierarchy, there is no diocese, then you would get the signature of the confirmation that your petitioner is within the denomination from another organization within the denomination. That organization might, I've not typically done this, but I think I will now that they're being very particular about it. I'm going to submit the tax exempt determination letter from the organization that certifies, to show that it's two different organizations and both are tax exempt.
Okay, that is very helpful. And state verification of nonprofit status does not suffice, right? It must be from the IRS. It must be federal.
It has to be from the IRS. And for example, I don't know if I mentioned this, these letters are sometimes 30, 40, 50 years old. Mm-hmm. They're addressed to the same organization at a different address, or the organization has changed its name. So until recently, the USCIS was a little lenient about that, but lately, practitioners in the field are reporting that they are becoming very difficult. But you can go back to the IRS and get a new letter that says, right, yes, we approved you in 1944, and you're still approved, because those things last forever.
Okay, good to know. Yes, and they may want to make their life easier and avoid questions. It may be worthwhile at the beginning to go back and get an updated letter. So that you have that. The question popped into my mind is, when we're talking about a religious denomination, I mean, with major denominations, it's pretty apparent that they are a denomination. But even if you have that IRS letter, you've got a religious or a religion, or a religious, what purports to be a religious denomination, they've got an IRS letter. Are there other situations where you can fall afoul of what the definition of a denomination is? Suppose you had a denomination which operates completely online, like they don't have an actual physical building to conduct services in, or they don't keep a regular membership list, or their services are so sort of free form that they don't have a liturgical or ritualistic style of worship. I mean, are there there must be sort of situations, these edge cases where you're dealing with small or newer denominations where, you can get questions from USCIS over whether it is in fact a bona fide religious denomination.
Yes, your clients will tell you, I am non-denominational. Well, that's a challenging case. You're going to have to prove that they are denominational, even though they say they're not, because because the rule is that the minister or religious worker has to be affiliated with the denomination for 2 years prior to the filing of the petition. So if this individual was abroad for 2 years, you're going to have to show that he was somehow a member of this denomination. So you're starting with an uphill climb when your client tells you we are non-denominational. But the key is understanding the definition of a denomination. A denomination is a group of religious worshipers or organizations that follow the same creed, form of worship, and principles of faith. So you're going to have to show that this individual was a member of a denomination abroad. It may have a different name, but it was a member of a denomination abroad that followed the same creed, form of worship, principles of faith that this church follows. Again, if your client tells you I'm non-denominational, you're going to have to work. Now, in my cases, I don't take any chances. I get a letter from the petitioner, from somebody in the petitioner's denomination in the United States saying, I'm familiar with this petitioner and they are a member of the XYZ denomination. The XYZ, the basic principles of faith of the XYZ denomination are 1, 2, 3, 4, 5. Then I get a letter from somebody abroad in the same or similar denomination that says the exact same thing. This beneficiary has been a member of our congregation or our denomination since before 2 years ago, and the basic principles of our denomination are 1, 2, 3, 4, 5, identical. So it makes it much more difficult for the USCIS to challenge that. Now, I'm not saying that's a fail-safe way of doing it, but in the denominations where I work, that typically does not run into a challenge. But yes, the denomination is something that you're going to have to concentrate on and convince the USCIS that the petitioner and the beneficiary are of the same denomination and that the beneficiary has been a member of the denomination for 2 years. If I can jump ahead to a green card, you will have to show that the beneficiary worked in a religious occupation within the denomination for the 2 years prior to the filing of the I-360 petition. So that denomination idea is very, very important.
Yeah, let's actually get to that topic about the differences between filing an I-129 to get an R visa and the difference between filing an I-360 to get a special immigrant visa for someone coming permanently. So aside from what they result in, the benefit that they result in, what are some of the other differences between those two petitions, and how does that play into how you would prepare the case?
Okay, so basically, for both petitions, you have to have the IRS determination letter. You have to establish that the beneficiary is a member of the denomination. You have to establish that the position that is either a minister or the person's in a vocation or fulfilling a religious occupation, such as a traditional religious function. The difference is that in the green card case, you have to show that the individual has been working for the denomination in a religious ministry, vocation, or occupation for the 2 years prior to the filing of the I-360. Typically, you would show that with letters from the organization abroad, or if the person is in the United States in R1, you would show it from your organization. Let's say, for example, the simplest example to explain is if the individual comes in an R1 and let's say 2.5 years into this, you get him an extension for another 2.5, and the organization says, let's get him a green card. So you have now employment records, tax records that show that this person was employed. I mean, when I file one of these 360s, I like to show 24 pay stubs. Somebody's getting paid monthly, I want to show 24 pay stubs. I will show his W-2. Sometimes I'll present his tax return. That will show that he's been in this occupation or vocation. Now, vocation is a little different. I'll come back to that. But as a minister or in the occupation for 2 years, if he or she has worked abroad for the 2 years, it's similar. You have to show tax records and things like that. It becomes challenging when the beneficiary was in a country where the tax system is not what we're accustomed to seeing here, where there are no records. For example, I just did one from the UK where there's no tax return. It's just a piece of paper that shows what was withheld from your income. Well, that worked. Apparently the USCIS is familiar with that. But there are countries where, third world countries where it doesn't work that way. So you're going to have to have a more robust set of evidence proving the 2 years of experience in the traditional religious function or the ministerial capacity. Now, in a vocation, nuns, for example, in the Catholic Church are not paid by the church; they're supported by the church. So you're probably going to have to show that the church, let's say a nun, for example, the congregation supported this person for 2 years. So it's the same concept. It's just the evidence is a little different.
All right, let's talk about this issue of the site visit. So tell me all about the site visit. This was something that was came into being in the early 2000s, around 2005 or so, due to concern about fraud. And originally it was like a discretionary situation where if USCIS had doubts, then they were authorized to conduct a site visit. But from what you're describing, that's now basically standard practice, or is that mandated that they conduct a site visit in all cases now? And is that for the I-129 for the R1 and the I-360?
Okay, so let me go back to the history of the site visit. In 2004, I believe, the USCIS conducted post-approval site visits. I actually had one. I was freaked out by it. A client called and said that the USCIS was there checking on my beneficiary, and I was just freaked out because I'd never heard of this before, and it seemed like an ominous thing. But as it turned out, it was part of a program to investigate to see if these things were legit. In 2008, when the regulations were published, they made it as a practical matter mandatory. I believe the language of the regulation is the USCIS may conduct a site visit, but as a practical matter, they require that site visit every time. It doesn't matter what denomination you are, they require it. Now, there's an exception to every rule. There are reports that when they were seriously backlogged over the last 18 months or 24 months, they did approve some cases from established denominations that did not have a site visit, but don't count on it. It's going to be required. Now, once you have the site visit, it is unclear how long it is good for. There's all kinds of talk among practitioners, but there's a belief that it's good for 5 years. Could be longer, but every case you do after that, if you want to do premium processing, you show them, I got this case approved. Okay, let's move on. They'll take it. But the site visit is typically done once, and sometimes post-approval also. Or sometimes if you file an I-360, you'll hear that someone came down and looked. These are FDNS officers, fraud detection, national security officers, who are not your typical USCIS officers, and they're coming down and to look at the facility, to see if it in fact exists, to speak to the person who signed the petition, to see if they in fact signed it, and to perhaps interview the beneficiary, and to review the books and records or ask for copies of financials for the organization. They also ask, okay, what's the person going to do? And what I'm seeing is, or my perception of it is, that they don't have the evidence that you submitted to the service center. They're coming blind. Now, they may know who signed the petition, but they're coming in blind. And I guess the concept is go in blind and see if they give you the same story that they gave the service center. So your client has to know this is going to happen. Somebody's going to come. Be familiar. Now, sometimes these are large organizations. The person that signed the petition doesn't exactly know what the beneficiary is doing. Well, he or she is going to have to know, what is the beneficiary doing? I had one recently where it's not a church, it's an office. It's an outreach organization. Okay, there's no pews to look at, but there's an office, and the person who signed the application, petition, was interviewed, and I made it clear to them ahead of time, you need to know the details. Sometimes they'll ask for financials. even though you've submitted the financials to the service center. They'll ask for job description. Sometimes they'll ask the beneficiary to email the officer a job description. All they're trying to see is if you're being consistent, if this is on the up and up, because what this test revealed in 2004, 2005 is that there are churches, I mean, that will, as a matter of sympathy, say, well, this person's going to have to leave the United States. Let's give him a job as a youth worker. Let's give him a job as a music pastor. And some of them were not legitimate, and that's what the USCIS is concerned about. I don't see those cases personally, but I don't know how much they exist today. But the USCIS is still back in the 15 years ago when this report came out.
Okay, I have a bunch of questions about these site visits. So first of all, does USCIS let the petitioner know in advance when they're coming? That's my first question. Does the petitioner, they don't let them know, they just show up without?
Sometimes there's an email saying I'm coming today or things like that, but typically no, they just show up. The FDNS officers will go on the web and see if your place actually exists, and they'll come. Sometimes it's problematic. Sometimes the petitioner is moved. I had a situation recently where the school had used its large auditorium for weddings. So on the web it said this is a wedding hall. So the USCIS sent a NOID saying, "Hey, this isn't the school. This is a wedding hall." And I had to respond and explain, "No, that's not true." There's no notice ahead of time.
Okay. Does the petitioner have the right to have counsel present during the interview?
I believe the answer is yes, but it's not a practical situation because the officer's not going to wait around till counsel shows up. But many attorneys do are on the phone. The petitioner has a phone, and you're listening to the dialogue, and it's not like entry at the port of entry. They don't exclude you. You are allowed to be there or participate. How much they let you participate is another question. I don't do that, but many practitioners do.
Okay. Do they record these interviews, or do they make a written record and ask the petitioner to sign the written record or take sworn statements during these interviews?
I'm not aware of that, but they do submit a written record a written report to the service center.
Does the petitioner have access to that?
As far as I know, they do not. Every once in a while, the practitioners in this field will circulate a template of what somebody found the FDNS officers are supposed to do. What are they supposed to ask? How's the interview supposed to work? But as far as I know, the report submitted to the service center is not available to the petitioner or the beneficiary. And the only way you know about it is if you get a notice of intent to deny or an RFE based on that report, and they tell you what's in it.
Do you have any, is there any judicial recourse, or is the situation where really the only legal pathway is you wait for this report to come out, you wait to see whether you get an RFE or a denial based on that report, and then you just need to go through administrative appeal? There's no other judicial remedy for that other than going the administrative route with the petition itself?
As far as I know, that's correct. You can't get an injunction against it, or you just got to file an administrative appeal. But I believe there are judicial remedies for denials of 129s. That's a different subject. I'm not familiar with it, but I believe there are. In a denial, if you get the denial.
And if they come for a post-approval site visit, they're just looking to verify the conditions of work and look that the person is actually doing what was specified in the petition. And have you any other insights onto what goes on during those? I mean, have you ever seen a petition revoked based on a negative post-approval report?
I have not had any petitions revoked based on a post, that I remember anyway, that on a post-approval site visit, but I'm sure it happens. I'm sure they are revoked when derogatory information is discovered in the post-approval site visit.
Okay. You want to add anything else about the site visit?
Your client has to be ready for it. Your
Okay.
client has to understand that the officer who's interviewing you does not have the documents that you submitted or may not have them, and that you have to treat this as, just another opportunity to sell your case to the USCIS. And another, you might want to say in your petition, for example, if it's a school, when it's closed for the summer. I often try to give information about who can be called, what is the cell phone number of the signer of the petition, although it's on the form. I will probably sometimes stick another sheet in there saying, this is the person you can talk to. If he's unavailable, talk to this person. Most of these FDS officers are sophisticated and competent to do what they do. Sometimes they get it wrong.
Mhm. All right. Now I wanted to ask one thing. I saw in the statute that the end of September, there was an extension of the non-minister special religious worker program. So these are people who are not ministers, but they are in a religious vocation or occupation. And it looks like that is something that has to be sort of extended periodically. So is that something in the law, right? There's a distinction between the clergy and the non-clergy with regard to the continuing validity of this section of the statute that authorizes the sort of the EB4 visas for the EB4 visa numbers for this category.
That's correct. When these came in 2000 no, these came in 1990. When these came in 1990, there was a 3-year sunset period attached to non-minister permanent resident cases. That's religious occupation, religious vocation, permanent resident. And like clockwork, I guess religiously you would say, Congress renewed those categories every 3 years. For for probably 20 years. Recently, there were certain senators who were careful, who were watching this. Senator Kennedy is one, Arlen Specter is another. They were concerned about this and they kept an eye on this, and their constituency brought this to their attention. And these 3-year sunsets were renewed like clockwork. But recently, with the inability to get anything done in Congress, particularly on immigration, there has been, this track record has gone off track. And but it has not fallen out of use. It has always been renewed as part of a budget reconciliation or some other legislative method of keeping this law going. I'm not personally familiar with the nuances of legislative action, but there's some way they keep it going. And what happens is when the government is going to, quote, shut down, then this is unavailable. So sometimes you will see in the visa bulletin that this EB4, this religious worker, is unavailable because it is anticipated the government will have a shutdown next month, and this is not, but it eventually will be renewed as part of a budget reconciliation or whatever the legislative mechanism is to keep the government open. And historically, it is not, it has always been available. It's just sometimes predicted or anticipated that it won't be available, and eventually it is available. So yes, Congress does need to renew this, and currently it's being renewed every few months as the government's budget is renewed.
Now, does this I mean, is this a date that you have to watch? Because if you get an I-360 approved for somebody who's in a non-ordained vocational occupation, or else maybe you have their dependents following to join on the basis of the approved I-360, do you have to watch this sunsetting date to make sure that you get them adjusted or get them interviewed for their immigrant visa before that date runs out, or is it pretty seamless?
In most cases, it's pretty seamless, but you have to keep an eye on the ability to file that 485 in a time when the visa bulletin permits you to do that. So you do have to keep an eye on this, but I've not had or heard of situations where people have been adversely affected by this inability to keep this legislation from sunsetting. But you do have to be aware of it. Practitioners do have to be aware of it, but I don't have an example of somebody who was harmed by it.
Gotcha. Okay, let's just talk about some of the other. We've done a good job with the R1 and the I-360 discussion. Let's talk about some of these others. You mentioned, sometimes if for whatever reason you feel like the case won't meet the requirements for the R1 category or the I-360, maybe you want to use an H-1B for either the principal beneficiary or for their spouse, let's say. You may want to use the H-1B. Can we think of some, but then of course you're going to run into the H-1B cap issues and the lottery and that sort of, that sort of thing. So that's far from an easy answer. It is a possible answer, definitely not an easy answer. How about some other categories? I mean, can you think of a situation where you'd have someone in a managerial capacity coming from abroad to work for a religious organization and you could possibly use an L visa? Do you think that?
I have not personally done that, but I've heard that it has been done.
Okay.
I'm sure it's not easy to get an L visa for a manager or specialized knowledge individual to come in L1. But in theory, it's possible if the church is no different than a business, and if the church has operations abroad that are financially tied to the operations in the United States, then I suppose it is possible, and I've heard of it being done, but it's not that common. I don't hear of it very often. One of the things that practitioners need to know about is the B1, the business visitor. If you look in the FAM, you will see that a business visitor employment, that it is possible for a business visitor, for a minister of religion or a religious worker to obtain a B1 to come to the United States to perform missionary work, as long as they're not paid from within the United States. And I actually do this from time to time, where you have young people as part of their religious orientation. They're coming to the United States to serve as missionaries. They all serve for no salary. Incidental expenses are okay. Those from Canada can just go to the port of entry and apply on this basis. And if the officers are in a good mood, they'll approve them. They should come armed with a letter that explains exactly what they're going to do, that there's no remuneration in the United States. And if you have questions, call the facility, call the organization that's sponsoring them, and they often do. The consulates will grant B1 visas to particularly young people who are part of their religious orientation, is to come to the United States and serve as a missionary to spread the word of the faith here, and that there has to be. I typically send them with a very detailed letter about what they're going to do and confirming how they're going to support themselves while they're here. So this is something that practitioners should be aware of. Now, is it practical to file a 539 to go from the end of your R status to B1? I guess it's possible. Yeah, it's certainly possible. The problem is it takes forever to get them to do a 539, but it is possible to suggest that this person is going to work for free as a missionary, and to cite the FAM as, I believe it's in the regulation also, it's in HCFR also, where this is a possibility. So that's something petitioners should keep in mind.
Okay, let's,
I do have one other issue that I think
absolutely.
petitioners should be aware of with the R1 and the 360 filings, and that is ability to pay. You've got to establish the ability to pay, and this is a sensitive issue with the USCIS, because they know that religious organizations operate on a shoestring budget. Now, if you're representing a large school, for example, a college, a religious hospital, I don't know if they still exist, but back 10 years ago, I did a lot of work for ministers who were serving as chaplains in religious hospitals, or if you're working for an order of sisters. These organizations often have audited financials where it's a no-brainer. But if you're dealing with a smaller church or a smaller organization that's actually running on a shoestring budget, you need to be aware that you need to show ability to pay. So you have to show them, for example, is this person replacing somebody to do this job? If so, submit the pay records of that person they're replacing. Submit the position description. Submit the qualifications of that person they're replacing to show that it's the same position, and then submit your budget. In any event, always submit your budget. But sometimes the USCIS doesn't give credibility to your budget. That's your budget. You put the numbers together. Now, another way to show ability to pay is a form called the IRS 990 form. Churches, synagogues, and mosques are exempt from filing a 990. So unless they file it voluntarily, you don't have the option of showing that they are that they filed a tax return or pointing to the income numbers on the tax return. But if your client files a 990, then you can show the income numbers on the tax return as evidence of ability to pay. If there's room and board in the position, submit a lease, submit a deed, show pictures. I always submit pictures of the building where the person's going to work, unless it's an office building and it's not a church or synagogue or school. Let's say it's an office building that you have a religious radio station, or you have a religious outreach program that function out of an office building. Okay, I don't send pictures there. But tax returns, pictures, budgets, evidence of past positions, pledges. I sometimes submit pledges saying, this is what I do, and I pledged X dollars to this position. That seems to work. Not always, but it seems to work. So you have to be aware that there is the ability to pay requirement, just like in every other I-140 case. So you have that here both in the I-129 and the I-360. Unlike a regular I-129, they're not going to be satisfied simply by answering the gross and net numbers on the form. You're going to have to show, it's in the regulations, you're going to have to show some kind of budget and be able to prove the budget. Bank statements are not really popular with the USCIS. They don't like them very much, but I suppose if you submit 12 months worth of bank statements, that might lend some credibility to your budget. So practitioners, be aware, ability to pay is an issue in these cases.
We have a question from our audience. I want to make sure I get to it. They asked the question, how to renew the R1 visa with a different petitioner for the I-129?
Just like you would do it in any other case. You would say, check the box that says change employer and file it. The difference is here, unlike an H case, it's not portable. You cannot begin employment with the new petitioner until the case is approved. But you can file the I-129, and on the front page, check the box that it's new employment with a new employer, and then ask for another 2.5 years, just like you would in an H-1B case. Ask for another 3 years, you ask for another 2.5 years going forward. One of the problems with the timing, I touched on this earlier, is you got to sort of anticipate how long this is going to take, because if you ask for, the day you file it is the first day, you go out 2.5 years. They're not going to extend it beyond the 2.5 years from the day they approve it unless your petition asks for that. So you got to keep an eye on that. But to change the position, yes, you just file a new I-129, and you're obligated to do it because these are employer specific, and when your beneficiary leaves the employment of the petitioner, there is an obligation to notify the USCIS, and it's an obligation that's undertaken right on the 129. The employer signs that they're going to do that.
And how many months should you allow for that? They asked a follow-up question. So since you're not authorized to work for the new petitioner on the date of filing, you have to wait for the approval. Around how many months should you allow for that to happen?
It is totally unpredictable how long the 129R1 will take at the California Service Center. That's where they're filed. Sometimes they come back in a month. Sometimes they come back in 9 months. I just can't predict it. You can look on the website and see what the time is. But if there's no site visit, there's been no site visit at the new employer, you're going to have to figure 3 to 6 to 9 months, something like that, as a minimum. Now, I did hear a report recently that somebody, I believe it was in Memphis, reported that a site visit occurred within a matter of weeks from the filing. So it's really unpredictable. It seems to me that what happens is somebody takes an initial look at this and says, hey, this looks bona fide, send the FDNS officer to see the place, and then we'll adjudicate it. Or somebody looks at it and says, this doesn't look bona fide, let's send an RFE, and if we're satisfied with the response, we'll send the FDNS officer. I don't know if it works that way or not. That's just the way, that's my perception.
Got it. So to the questioner, as early as possible would be a good guideline. How about in terms of when to file an I-360 for somebody who is, using their 5 years of R1 status? I mean, if you wait till the 4th year, are you running a risk? Is obviously, go ahead.
Many practitioners will wait until the the first extension, the second 2.5 years is approved. I frankly don't see that they are denying I-360s because you have filed a 129 to extend the R. I'm sorry, I get it backwards. I'm not seeing that they're denying the 129s because you filed an I-360. Now, obviously, as practitioners, we're always concerned about immigrant intent, but I'm not seeing that a problem, but many practitioners will wait. I believe the FAM says that you have to have that immigrant intent, that non-immigrant intent means that you have a place to live abroad. It's not like 214B, it's a little different, but that doesn't mean in practice it works that way. I just want to point out, we've seen when you get an I-129 approval with a approval notice of I-797 that you could take to the consulate, it used to be there was a 99.99% approval rating. But we're hearing information now that at certain consulates they're not approving them as easily as before. I believe that in certain posts there is a feeling that the person went to the United States as a visitor to seek out this employer, and there's some question about the legitimacy of it. And when they go back, and they travel back, so they get a change of status. They came on a B1, they get a change of status, they stay here for a year, they go home to visit, they try to get their visa, and occasionally you hear stories that they've been denied the visas. So be aware of that, and your client expectation should not be that it's a slam dunk to get the visa. And there are certain posts I've heard about in London recently, which is surprising. Jerusalem is one. Pakistan is another, and there's other posts in South America where there are difficulties with these cases. But for the most part, they get approved. But don't feel it's a certainty.
Okay. And they asked the last question, which I can answer. What's the earliest to submit the I-360? There's really no earliest. As soon as you feel that you have all of the documentation in hand and you can meet every prong of the requirements, you don't have to be in R1 status to that is not linked legally to having an I-360 filed. So you can just go right to the I-360 as soon as you can.
It's like a labor certification.
Right.
You could go right to labor certification even if the employee is still abroad.
Abroad.
But it's hard to prove a 360 from abroad. You have to have the right tax documents and other evidence of the 2 years of employment.
There you go. Well, we just have a couple minutes left, so I do want to, if anyone in the audience has any remaining questions, please put them in the Q&A now. We are going to have by the way, the video of today's meeting available, and you can look at it again. We're going to share that, of course, on our YouTube channel. Joel, about getting into this niche, let's just mention that for a minute. So do you have any advice for people who are thinking about getting into the religious worker niche in terms of how to reach this client base, where to network, where to advertise, and professional networking? Any particular organizations or committees, either within ALA or other lawyer associations that focus on this niche?
Okay, I'm much better at the substance of this thing than the marketing of it, but Let me say this. I would say that the key to getting into this is finding your first case, doing a good job, being intelligent, having read the regulations. And I didn't mention, the USCIS has on its website a policy manual, which was recently published. You should be familiar with it. It was published about 2 months ago. It's on the website. It's called Policy Manual for Religious Worker Cases. You should read it. Be knowledgeable. The first person you talk to on this subject, act like you've done 100 of them. They're very impressed, and do a good job. And it's a word of mouth business like anything else. AILA has a religious workers interest group that meets once a month online. Any AILA member can join it. I'm sure there's information about it on the website. It's a pretty sophisticated group of people, so if you're an entry level, you might not appreciate it, but there's always good information being passed out there.
Okay, great to know. Well, this has certainly been a very informative and very substantive discussion. I want to thank again Joel Pfeffer, an attorney with Meyer, Unkovich, and Scott in Pittsburgh, Pennsylvania, for being my guest. Thanks to our audience, and please join us for our next webinar.